Welcome to Real Estate School. By now, you've probably watched dozens of videos and taken hundreds of practice tests to prepare yourself for your state's licensing exam. I want to do something a little bit different. I want to give you an exam that's more comparable to what we'll give students in our classroom. I've been teaching real estate pre-licensing for decades, and I got a pretty good feel for what you might see on your licensing exam. So if you pass my exam, you can feel pretty confident you'll do well on your licensing exam. So how we're going to do this a little bit different is I'm going to give you 20 questions and answers, A, B, C, and D, but we're not going to give you the correct answer till the end. So what I want you to do, pull out a sheet of paper, grab a pen, and as we go through the exam, write your answers down. We'll grade them at the end. This is going to be a 20-question exam. The passing grade is 70%. So of the 20 questions, you can still miss 6 and you pass with a 70%. This is going to be fun. What do you say we get started? Question number 1 is going to be, how is a conventional life estate created? A, it happens automatically when title transfers, unless a fee simple is specifically claimed. B, a fee simple owner grants the life estate to a tenant. C, it is created by judicial action. D, it is created by a statutory period of adverse possession. Question number 2. 3 people have identical rights, but unequal shares in a property, share an indivisible interest, and may sell or transfer their interest without consent of the others. This type of ownership is A, joint tenancy, B, equal ownership, C, tenancy in common, or D, estate in severalty. Question number 3. Unlike tenants in common, joint tenants, A, own distinct portions of the physical property. B, cannot will their interest to a party outside the tenancy. C, may own unequal shares of the property. Or D, cannot sell their interest to outside parties. Question number 4. What distinguishes a lien from other types of encumbrances? A, it involves a monetary claim against the value of a property. B, it lowers the value of a property. C, it is created voluntarily by the property owner. Or D, it attaches to the property rather than the owner of the property. Question number 5. The only required clause in a deed of conveyance is one that A, states restrictions and limitations to the estate being conveyed. B, states the parties and the type of estate being conveyed. C, states that the grantor has done nothing to impair title to the property being conveyed. Or D, states the grantor's intentions, names the parties, describes the property, and indicates a consideration. Question number 6. The type of statutory deed that contains the most complete protection for the grantee is A, guardian's deed, B, special warranty deed, C, general warranty deed, or D, quitclaim deed. Question number 7. If a lease does not state a specific ending date, when does it terminate? A. Immediately, since it's an invalid lease. B. After 1 year. C. When either party gives proper notice. Or D. Whenever the property is sold. Question number 8. A buyer agrees to all terms of a seller's offer except price. The buyer lowers the price by $1,000, signs the form, and mails it back to the seller. At this point, the seller's offer A. is void. B. becomes an executory contract. C. becomes a counteroffer. Or D. has been accepted. Question number 9. A property seller empowers an agent to market and sell a property on his behalf. This is an example of A. general agency, B. special agency, C. universal agency, or D. no agency. Question number 10. Implied agency arises when A. an agent accepts an oral listing. B. a principal accepts an oral listing. C. a party creates an agency relationship outside of an express agreement. D. a principal agrees to all terms of a written listing agreement, whether express or implied. Question number 11. An agent owes customers several duties. Those may be best described as A. fairness, care, and honesty. B. obedience, confidentiality, and accounting. C. diligence, care, and loyalty. Or D. honesty, diligence, and skill. Question number 12. Agent Bob, who works for broker Jennifer, obtains an owner listing to lease a building. Jennifer's other agent, Madeline, locates a tenant for Bob's listing. In the absence of any other arrangement to the contrary, broker Jennifer in this instance is A. an implied agent, B. a dual agent, C. a single agent, D. a sub-agent. Question number 13. Owner agents must disclose their agency relationship to tenants or buyers A. immediately prior to the initial contact, B. upon initial contact, C. whenever substantive contact is made, or D. immediately following any offer executed by the customer. Question number 14. The type of listing that assures a broker of compensation for procuring a customer regardless of the procuring party is A. An exclusive right to sell agreement, B. exclusive agency agreement, C. open listing, or D. net listing. Question 15. The amount of a real estate broker's commission is A. established among competing brokers, B. established through negotiation with clients, C, established by the Board of Realtors. Or D, established by the state real estate license laws. Question number 16. Which of the following best characterizes a conventional sales contract? A, voluntary, unilateral, and executory. B, involuntary, bilateral, and contingent. C, voluntary, bilateral, and executory. Or D, involuntary, unilateral, and executory. Question number 17. The roof of a property cost $10,000. The economic life of the roof is 20 years. Assuming the straight line method of depreciation, what is the depreciated value of the roof after 3 years? A, $10,000. B, $8,500. C, $7,000. Or D, $1,500. Question number 18. A lender lends money to a homeowner and takes legal title to the property as collateral during the payoff period. They are in A, title theory state. B, lien theory state. C, states allowing land trusts. Or D, states where hypothecation is illegal. Question number 19. When the terms of the mortgage loan are satisfied, the mortgagee, A, may retain any overage in the escrow account. B, may inspect the property before returning legal title. C, may be entitled to charge the borrower a small fee to close the loan. D, may be required to execute a release of mortgage document. And question number 20. Which of the following laws or rulings extended discrimination to include gender, handicap status, and family status? A, Executive Order 11063. B, the Civil Rights Act of 1968. C, the Fair Housing Amendments Act of 1988. Or D, Jones versus Mayer. Well, hope you did well. Let's go through the answers. Question number 1 was, how is a conventional life estate created? And the answer is B. A fee simple owner grants the life estate to a life tenant. I own land. I can grant to somebody else that ownership through a deed and state in the deed that I'm granting this ownership to them for their life. And once their life ends, that ownership would transfer back to me. That is a conventional life estate. Ownership for the duration of somebody's lifetime. Question number 2. 3 people have identical rights but unequal shares in a property. Share an indivisible interest and may sell or transfer their interest without the consent of the others. This type of ownership is C, a tenancy in common. To me, what stands out is they have unequal shares. That's going to eliminate joint tenancy. Estate and severalty is just for husband and wife. The answer would be C, tenancy in common. Question number 3. Unlike tenants in common, joint tenants? The answer is B. Cannot will their interest to a party outside of the tenancy. Joint tenancy has rights of survivorship. And what that means is when one of the co-owners passes away, their ownership is absorbed by the other co-owners. Essentially, there's one less owner that owns the entire property. If there are 4 owners of a property to begin with, each would own a 25% share. One of those co-owners passes away, now we're left with 3 owners that each own a third. One of those owners pass away, we're left with 2 owners that own the property 50-50. Finally, one of those 2 owners passes away, now we're left with 1 owner that owns the entire property. And what do they call that? Ownership in severalty. So joint tenancy is designed that way. As the co-owners pass away, ownership reduces down to ownership in severalty. Our next question. Question number 4. What distinguishes liens from other encumbrances? And the answer will be A. It involves a monetary claim against the value of a property. A claim made by a creditor that attaches to the property. It reduces its value, but it does not prevent transferability, which is, by definition, an encumbrance. A lien is a type of encumbrance, but it's a lien is monetary. It's based on money owed. Question number 5. The only required clause in a deed of conveyance is one that? The answer is D. States the grantor's intention, names the parties, describes the property, and indicates a consideration, and this is what we would call the granting clause. The opening clause in the deed that tells us a lot about what the seller's intentions are as far as what type of ownership and intentions in transferring that ownership to a buyer. The granting clause is the only required clause in a deed. Question number 6. The type of statutory deed that contains the most complete protection for the grantee is... I'm thinking we probably all got this one right. C is the answer, a general warranty deed. A general warranty deed contains the most promises that the seller is making to the buyer. If this happens after you buy my house, I'll make that good. General warranty deed. Question number 7. If a lease does not state a specific ending date, when does it terminate? And the answer will be C, when either party gives proper notice. This most likely is what we learn to be a tenancy at will, which is a tenancy, a lease that has a start date but no ending date. The lease would require a notice. It would terminate with either party would give proper notice. Question number 8. A buyer agrees to all terms of the seller's offer except price. The buyer lowers the price by $1,000, signs the form, and mails it back to the seller. At this point, the seller's offer, and the answer is A, is void. I know some of you might have answered becomes a counteroffer, and that's what happened. By changing the terms of the offer and sending it back, it becomes a counteroffer. But as a result, and the question asks, at this point the seller's offer is void. A is the answer. A property seller empowers an agent to market and sell a property on his behalf. This is an example of, well, in the real estate business, 2 types of agency, special agency and general agency. The answer here is special agency relationship. Listings and sales are generally considered special agency because the agent has one specific task. Find a buyer for my house or find me a house to buy. Property management is an example of general agency relationships. General agents have a special power. They can sign contracts and bind their client, the person they represent. Think about it. Normally the property manager signs the lease with a tenant, binding the owner to the tenant. Another example of general agency relationships would be your relationship with your broker, real estate agent to broker, is a general agency relationship. When you go take a listing in most states, you don't have to have your broker sign the listing agreement. You sign the listing agreement binding your broker to the seller. That's the power of a general agent. Our answer here, though, was B, special agency relationship, listings and sales. Question number 10. An applied agency arises when? Our answer is a party creates an agency relationship outside of an express agreement. Many states, including the state I'm in, says without anything other than a written agreement would be considered an implied agency. Let that sink in. Our next question. Question number 11. An agent owes customers several duties. Those may be best described as, and the answer here is A, fairness, care, and honesty. Let's not forget who the customer is, the unrepresented third party. This party is representing themselves. We owe clients obedience, confidentiality, accounting. Those are the duties of an agent. A customer, a party that's representing themselves, we still have to treat them with fairness, care, and honesty. Question number 12. Agent Bob, who worked for broker Jennifer, obtains an owner listing to lease a building. Jennifer's other agent, Madeline, locates a tenant for Bob's listing. In the absence of any other arrangement to the contrary, broker Jennifer in this situation is, and the answer is a dual agent. A dual agent, B. So what do we call this relationship? What do we learn? This is called designated agency. Designated agency. Dual agency exists when we have one agent that's representing both buyer and seller in the same transaction. Designated agency, probably even more common, especially if you work for a big firm. We have two different agents involved in both sides of one transaction. One agent has the home listed, another agent in the firm finds the buyer. Two different agents. Here's the thing. In this case, broker Jennifer, being the broker who the transaction is actually through the broker, broker Jennifer is still representing both parties in this one transaction. It's just we're using two different agents. It's a form of dual agency, but it's a better form of dual agency. Designated agency. Two different parties or two different agents are involved. Now at least we can preserve that duty of confidentiality. As a dual agent, how do you keep information confidential from yourself? In this case, Bob and Madeline can discuss the transaction with broker Jennifer, and what broker Jennifer learns about both parties, broker Jennifer would have to keep confidential. Our next question, question number 13. Owner agents must disclose their agency relationship to tenant or buyers, and the answer is whenever substantive contact is made. Here's a point we like to enforce in real estate school to our students. We always disclose who we represent to the party that's not being represented. That's the customer. The party is yet to hire a real estate agent. They're out shopping on their own. Whenever we discuss a property, our listing or another's listing, we have to disclose our relationship. I'll be happy to tell you about that listing, but please understand I represent the seller before we proceed to discuss the property itself. This is the customer. In my state, it's done verbally over the phone, but when you first meet that buyer in person, it has to be in writing. So when we first meet a buyer to show them a property in person, they have to sign something. Either a buyer representation agreement or a form where the disclosure is made to that buyer that we are not representing the buyer, we're representing the seller upon first substantive discussion about a specific property. Question number 14. The type of listing that assures a broker of compensation for procuring a customer regardless of the procuring party is A, an exclusive right to sell agreement. The broker is guaranteed a commission no matter how the home sells. Even if the seller finds the buyer themselves, the seller still has to pay the broker the full commission. As opposed to exclusive agency, where in this arrangement, the seller is entitled to find the buyer themselves. If the seller finds the buyer without another broker involved, the seller doesn't have to pay a commission. So yes, the answer here to 14 is A. Question number 15. The amount of a real estate broker's commission is? The answer is B. Certainly, established through negotiation with clients. Our real estate board, our real estate licensing laws want an open and competitive markets. There is no such thing as a standard real estate commission or a going rate of commission. Brokers individually negotiate their commissions with their clients. B is the answer. Number 16. Which of the following best characterizes a conventional sales contract? The answer is C. A conventional sales contract is voluntary, bilateral, and executory. Break it down. The parties voluntarily entered into this agreement together, as opposed to involuntary. Bilateral means that both parties are bound to each other to perform in this contract, as opposed to unilateral, when only one party is bound. My best example of that would be a coupon in the newspaper is a unilateral contract. You don't have to use that coupon, but if you use that coupon, the store has to give you the discount that's promised. Only one party is bound. That's unilateral. A sales contract is bilateral. Both parties are exchanging promises. And executory, which pretty much means the contract's in the process. All the terms have yet to be met. A purchase agreement is executory from the time it's signed until closing. At closing, it becomes executed. Till then, it's executory. Question number 17. The roof of a property costs $10,000. The economic life of the roof is 20 years. Assuming the straight line method of depreciation, what is the depreciated value of the roof after 3 years? Well, straight line depreciation. We're always giving a lifespan and a value, and we simply divide the 10,000 value by the 20 years. That means on a straight line basis, this roof loses $500 value per year. And if we multiply the $500 per year times the 3 years of life so far, that's $1,500. So if the original value was $10,000 and it's now lost $1,500 in value, the remaining value would be B, $8,500. Question number 18. A lender lends money to a homeowner and takes legal title to the property as collateral during the payoff period. They are in a title theory state. States that use mortgages as collateral are called lien theory. States that use a deed of trust to establish collateral are called title theory states. In lien theory states, the homeowner has full ownership of the home. The bank has a lien on the property, but it's no more than that, a lien. If the homeowner quits making payments and the lender wants to foreclose, the lender has to go to court to get the judge's permission. Lien theory states use mortgages, and mortgages usually require judicial action to foreclose. Title theory states, at closing, the home buyer signs a deed transferring their ownership of the property to an attorney, the trustee, to hold in trust while we're paying off our mortgage loan. So in title theory states that use deed of trust for collateral, the homeowner gives up their ownership and doesn't require that or regain that ownership till they've paid off their loan. Upon that point, the attorney returns ownership to the home buyer through what they call a deed of reconveyance. That's title theory. A is the answer. Question number 19. When the terms of the mortgage loan are satisfied, the mortgagee, who's the mortgagee? The mortgagee is the lender. And the lender, D, may be required to execute a release of mortgage document. That's how they remove their lien from the property. They're going to go down to the city or county and file this release of mortgage to remove the lien from the property. Our final question, number 20. Which of the following laws or rulings extended discrimination to include gender, handicapped status, and familial status? This was an amendment to the Fair Housing Act. The answer is C, the Fair Housing Amendments Act of 1988. Well, I am certainly hoping you passed your exam with flying colors. But if you didn't, it's not the end of the world. This was just practice. A good example of what you might see on your final exam, but it was just practice. Any one of these subjects that you feel like you need some more preparation and more studying with, we have several good videos here on our channel. Please enjoy those. And let us know of any other subject you'd like us to cover. Hit that subscribe button, ring that bell, and we'll keep you up to date of our new videos as they come out. Thank you.